taught in the schools of nursing and medicine for 13 years before joining the Missouri University Law faculty in 1993 as director of the Family Violence Clinic. She's a semi-retired Emerita professor. Her work history includes a law school-based practice representing indigent domestic violence victims and dying custodial parents, a private law practice consulting in adoption, assisted reproductive technology, and serving as faculties in the schools of nursing and medicine, working as a certified family nurse practitioner at the Columbia Free Clinic, which I remember, and other walk-in clinics, and at the Missouri University Hospital and Clinics, also drafting multi-state legislation involving birth parent rights, adoption of children, standby guardianship, and domestic violence. And Mary's also an original member of the Missouri Battered Women's Clemency Coalition and has participated in domestic violence, clemency, advocacy, and litigation. Okay. Wow. No, quite a history both Mary and Margie have in this. Margie, bio. After getting her MSW from Washington University, Margie worked at Reproductive Health Services in St. Louis as an abortion counselor. She then moved to Columbia in 1978 to direct the agency's counseling and referral office. She worked as a faculty-based field instructor for MU School of Social Work, and then as an obstetrics social worker at MU Hospital, working with pregnant adolescents and high-risk pregnancies before leaving to pursue her doctorate in public health at the University of North Carolina. She then worked for 5 years at Missouri Department of Health in Jefferson City as a bureau chief of the Bureau of Perinatal and Child Health, and then at the Missouri Family Health Council before rejoining MU School of Social Work in 1994, where she was on the faculty until her retirement recently, 2016. She was the school's director for the last 9 years. She has been on the board of Planned Parenthood Great Plains for 8 years, serving as board chair from 2016 to 2018. She's definitely a long-term activist for reproductive rights, and she can't wait to start gathering signatures for the initiative petition. Thank you, Mary and Margie, for being here today.
My pleasure.
Okay, I'm trying to share my screen. Okay, thank you, Alice, and hi, Mary. Mary and I have done this presentation, as Alice said, at the League of Women Voters, and I guess we're taking it on the road. So I'm no longer on the board of Planned Parenthood, by the way. I termed out, but I'm still very involved with it, and I agreed just a few days ago to be the point person for League of Women Voters on the initiative petitions, but they are not yet printed. And, we're just waiting for our marching orders. And as soon as I know something, I'll let everybody know. So, this presentation is on reproductive rights, where we've been and where we're going. The turning point, of course, was the Dobbs decision. So I'm going to be talking about reproductive rights, 100 years of history. It's actually a little bit more than 100 years, and then up to the Dobbs decision, which occurred in June of 2023. And then Mary is going to talk about implications since around abortion since the Dobbs decision. Okay, so as you all know, it was 2022, how time flies. The Supreme Court overruled Roe v. Wade and Planned Parenthood versus Casey, giving states the rights to regulate any aspect of abortion. And boy, have we seen that here in Missouri, where we are not able to do any abortions, not even for the fetal health or maternal health. Some history. Abortion was done mostly by midwives prior to the Flexner Report of 1910. And the Flexner report certified doctors as being basically competent or not competent to practice medicine, and it ruled out a lot of the work that midwives were doing. Also, I heard a program yesterday on NPR about how it also ruled out a lot of the Black doctors because they didn't have enough resources to qualify for the guidelines that he had set forth in his report. And sadly, the suffragists were not in favor of abortion. Anthony Comstock, who lived between 1864 and 1916, was a special agent of the United States Postal Service. He was also head of the New York Society of the Suppression of Vice, and was dedicated to upholding Christian morality, whatever that was. And laws were passed that are known as the Comstock laws in 1973 that basically prohibited access to contraception on the grounds of obscenity. And I'll talk a little bit more about that in the next slide. The Comstock laws were rendered null and void in the 1965 Griswold versus Connecticut decision and the 1972 Eisenstadt versus Baird Supreme Court decisions, but not completely, because even now, if you've heard people talking about sending abortion pills through the mail and how that's not legal in some states, the states that are not allowing it are using the Comstock laws as a basis for that and saying, you can't send these through the mail. So he hasn't, his laws are kind of living on, even though they were overturned. So the act that passed, known as the Comstock laws, criminalized any use of the United States Postal Service to send contraceptives, abortifacient, sex toys, things that were deemed to be obscene, personal letters with any sexual content or information, or any information regarding the above items. And in DC, where the federal government had jurisdiction, it also made it illegal to sell, lend, or give away any obscene publications or articles used for contraception, and it was punishable by up to 5 years of hard labor. Amazing to think about that. Does anybody know who this is? You'll have to unmute yourself to tell me. And the people who heard this at the League of Women Voters can't say. Anybody?
It's Margaret Sanger.
You're right, Dave. Margaret Sanger, who was a heroine of the birth control movement. She was a birth control advocate and sex educator. She was a nurse and a social activist. And in 1914, she opened the first birth control clinic. In 1916, she was arrested for distribution of contraceptives and information pamphlets, and she was jailed under the Comstock laws for distributing birth control information. So her legacy was that she founded in 1916 the American Birth Control League that evolved into the Planned Parenthood Federation of America, which is still in existence today. And in 1929, she founded the National Committee for Federal Legislation on Birth Control. So she was really a heroine, really, for all of my time working in the reproductive rights movement. But she was also embroiled in the eugenics controversy and was an advocate for a lot of the eugenics measures that were proposed during her time. And so now she's not hailed so much as a heroine and is being discredited because of her involvement in the eugenics movement. An example of this is that the flagship clinic of Planned Parenthood of New York City was called the Margaret Sanger Clinic. And about a couple of years ago, they changed the name because of her association with eugenics. And that happened in large part due to the Black Lives Matter movement and more, people being aware of some of the discriminatory practices and just not wanting to be associated with the controversy. But in many ways, she was still a heroine for the work that she did on advocacy for birth control. So again, I'm not doing this live, so I won't ask you to raise your hands if you were married before 1965, but I know a few of you were. And if you lived in Connecticut, it would have been illegal for you to have practiced birth control, even if you were married. And Estelle Griswold, who was the executive director of the Planned Parenthood League of Connecticut, and she was a civil rights activist and a feminist. She wanted to overturn that law, those laws in Connecticut. And she filed a suit. It was known as Griswold versus Connecticut, and the Supreme Court overturned that, citing a constitutional. They overturned the Connecticut laws, citing a constitutional right for privacy. So we have Estelle Griswold to thank for married people being able to use birth control. You'll be glad to know. And then another law that basically granted the right for unmarried people to use contraception was called the Eisenstadt versus Baird. And that established the right of unmarried people to possess contraception and to use it on the same basis as married couples. Along with that, the court struck down a Massachusetts law that prohibited the distribution of contraceptives to unmarried people for the purpose of preventing pregnancy, and they ruled that it violated the Equal Protection Clause of the U.S. Constitution. So basically, it effectively legalized premarital sex in the United States because they allowed the use of contraception. Okay, so then we see abortion was illegal all this time, but in the late 60s and early 70s, some states started legalizing it. One was the state of California, and Governor Ronald Reagan signed that law legalizing abortion. It was amended in 1971 to require that a woman be a resident of the state of California for 30 to 90 days in order to get an abortion. And Hawaii, Alaska, and New York were other states that legalized abortion during this time. I remember when I lived in St. Louis, there was an organization, a national organization, and there was one in St. Louis called the Clergy Consultation Service, which was formed to assist women from states that where abortion was not legal to get to other states where it was. And in St. Louis, they sent women to a clinic in New York, the Dobbs Ferry Clinic, and helped women financially also to get there. So as I said, Ronald Reagan signed the legalization of abortion into law in 1970, and Richard Nixon also was president when the Title X Family Planning Act was passed by Congress. He said, "It's my view that no American woman should be denied access to family planning because of her economic condition." It was co-sponsored by George Herbert Walker Bush, and the Title X Family Planning Act provided funding for family planning services to low-income women. I believe you had to be below 100% of the federal poverty level. But I did, when I was a faculty-based field instructor, there was a Planned Parenthood clinic in Fulton where I was based, and it was, a small clinic, but they did have Title X funding to assist low-income women, and that included women from William Woods College, as well as any woman in the area who didn't have enough money to go to a private doctor to get birth control. Okay, and then January 22nd, 1973, we had the landmark Roe versus Wade decision that legalized abortion through the second trimester of pregnancy. Very soon after that, and I should say that I was working at Reproductive Health Services starting in 1975. And I remember when the Hyde Amendment was passed, it banned Medicaid funding for abortion, and except to save the life of the mother. So Medicaid abortions dropped from 300,000 per year to just a few thousand per year. And we had been able to use Medicaid. Women coming to Reproductive Health Services were able to use their Medicaid to pay for their abortions. But after the Hyde Amendment ruling, they were no longer able to do so. And that limited a lot of the number. They could scrape together funding from other sources, and the clinic helped them by lowering the cost, but still a lot of women were unable to access abortions because of the Hyde Amendment. And it is still in force today. Many of you remember our Attorney General, William Webster, and in 1986, the legislature passed some anti-abortion laws signed into law by Governor John Ashcroft. It prohibited the use of public facilities, employees, or funds to provide abortion counseling or services. And it placed restrictions on the physicians who provided abortions. So, for example, some of the residents at the MU hospital and clinics would moonlight and do abortions at Planned Parenthood because they were at MU hospital and clinics, which received federal funding. They were no longer able to do that. And this law also established the precedent that states could provide restrictions to abortion care. The domestic gag rule and the international gag rule forbade health workers working in sites that had Title X funding. Those included Planned Parenthood clinics, health departments, community health centers, any clinic that had Title X funding, from discussing abortion or referring women for abortion. They just weren't allowed to give that information, and they had to say, if a woman came in for a pregnancy test, they had to say, "I'm sorry to tell you that we are not able to give you any information," if they were asked about where they could go for an abortion. So the Title X gag rule has gone back and forth depending on who is president. So under the Republican administrations, the gag rule has been enforced, and under the Democratic administrations, currently under President Biden, it is not enforced. So currently, this information is able to be given to patients. And this applies also to the international gag rule to countries that receive federal funding for international family planning. There's a similar gag rule that is either enforced or not enforced, depending on who's in office. Okay, minors. We had a couple of laws about minors. Minors typically had to have, when I was working as an abortion counselor, if a minor wanted to get an abortion, she had to have permission of her parents. They had to come and sign for her. The 1990 Hodgson versus Minnesota and Akron versus the Center for Reproductive Health laws upheld two parental involvement laws. And so the states that didn't require parental consent then had to start enforcing that. Planned Parenthood versus Casey was an important important ruling from the Supreme Court. It had good and bad aspects. The good thing was that the court retained the essential holding of Roe. So the people who were bringing this were trying to overturn Roe v. Wade, but Casey did not overturn Roe v. Wade. But the bad part was that it rejected the trimester standard. Remember, I said before that Roe v. Wade allowed for abortion through the second trimester of pregnancy. So it rejected the trimester standard in favor of a new undue burden standard. So in later term abortions, women had to show that there was going to be an undue burden on them in order that would allow so that they could get an abortion. And here I just put some pictures. You all know that this has been really a very high emotionally charged issue on both sides. And we've seen throughout the years many demonstrations, both for the legalization, keeping abortion legal, and trying to make it illegal. There were, as you know, in Colombia, we have people at the Planned Parenthood clinic every day protesting, even though abortions are not done there. They haven't performed abortions in Colombia for many years, but the protesters are still there. They're not very highly charged because abortions aren't done, but there have been some really horrible efforts of the anti-abortion demonstrators to harass patients and really make it difficult for women coming to the clinics for abortions. So there were some cases involving trying to make the abortion protests illegal, but the court had several rulings upholding the right for anti-abortion blockades at the clinics. You can see in 1993, 94, and 2006. So it rejected, one said that they didn't violate any civil rights statute or a conspiracy against women, and they rejected part of a free speech challenge. And in Scheidler versus the National Organization of Women, it said that the Hobbs Act didn't cover violence unrelated to robbery or extortion, and that the RICO Act didn't apply to blockaders' actions. So they are still allowed to protest, and most abortion clinics have just put up barriers like fences or walls to separate the protesters from the patients. But we do have escorts still working, volunteer escorts, to help women get from their cars into the clinics and make them feel a little bit safer and tell them not to worry about the protest, just to ignore the protesters. And they're also told not to engage with the protesters because it doesn't do any good. Okay, partial birth abortion is another law that has been proposed, and partial birth abortion refers to late-term abortions when a procedure called dilatation and evacuation. It might have other names, but it's a procedure used for late second trimester abortions that often used laminaria, which is something inserted into the woman's cervix to slowly dilate it overnight to make it easier for the abortion to take place. And second trimester abortions are often used for when there's a genetic problem or a complication with a pregnancy where, for example, the woman from Texas who had to leave Texas to go to another state, even though she had a pregnancy that threatened her life. And Mary will talk more about that. But a lot of these second trimester abortions are for those purposes. But the anti-abortion side started calling them partial birth abortions just to try to make it seem like it was really a birth at that stage of pregnancy. So it was really rhetoric that was inserted to make it more difficult for women. And Congress did pass that law in 2003. And in 2007, the Supreme Court upheld the Partial Birth Abortion Ban Act. TRAP laws refer to targeted regulation of abortion providers, and these are just really kind of pesky, harassing laws that have nothing to do with what is medically safe or necessary. It's just laws that have been designed to make it more difficult to do abortions and to shut down abortion clinics. So one of those has to do with requiring doctors to have hospital admitting privileges at a nearby hospital, the 24 and 72-hour waiting periods for women, and requirements that clinics comply with standards of ambulatory surgical centers. So they have to have, the hallways have to be wider than normal, the doors have to be wider than normal. It required that the clinics basically remodel their clinics at their own expense to comply with ambulatory surgical centers when that wasn't really needed. And reporting requirements that providers refuse to provide about patients. You might recall former director of the Missouri Department of Health was requiring the only clinic in St. Louis, in Missouri, that was doing abortions that time was the Planned Parenthood of St. Louis. And he was asking them to provide information about the patient's last menstrual period, which was none of his business. And they refused to do it. But those kinds of things are kinds of, and ultimately he was not successful in getting it. But those kinds of laws are just really harassment and known as trap laws. Another requirement, it was for the medication pills, abortion pills, to be dispensed in person by a physician. And first of all, it's not necessary for a physician to do it. A good nurse practitioner like Mary Beck could do it just as easily. But requiring that it be done by a physician was a way to make it more difficult for clinics to operate. And also, going back to the Comstock laws, requiring these pills to be dispensed in person meant that they couldn't send the pills to the patients in the U.S. mail. This is a picture. This was from December. It's published by the Guttmacher Institute, which is an institute that does research and policy research around abortion and reproductive health. This is updated all the time, so it might even have changed since December when I put it on the slide. And it shows where the most restrictive and most lenient states are for abortion. You can click on any of these states. It's an interactive map, and you can click on any state and it will bring up what the laws are in that state. So it's really very handy if you're interested in looking at that. And I'm not going to click on it now, but I just wanted you to know that it exists. And here's the website for it if you're interested in doing that, states.guttmacher.org/policies. So if you're interested in checking out other states, it's very interesting, and they do update it. So as laws change, as they do seem to be changing almost every day in some states, you can see what the current policies are. So there have also been many amendments and trigger laws. In 2008, Colorado passed the first of many personhood amendments, giving personhood status to a fetus, thus rendering abortion illegal. In 2010, Nebraska became the first state to pass a fetal pain law, banning abortion at 20 weeks instead of the 24 weeks where it was legal in that state at that time. And in 2019, Missouri passed a trigger law that stated that no abortion shall be performed or induced upon a woman except in cases of medical emergency, and it was to take effect after the Supreme Court has overruled in whole or in part Roe v. Wade. So that meant that on the day of the Dobbs decision, this law was already on the books, and so on that day, this went into effect, so that abortion became illegal because this trigger law was already on the books in Missouri. We did finally have a good ruling by the Supreme Court in the Texas case of Whole Women's Health versus Hellerstedt in 2016. And that ruled that Texas couldn't replace restrictions on the delivery of abortion services that created an undue burden for women seeking an abortion. And it centered on two TRAP law provisions. The one was the mandate that all abortion providers comply with the onerous and medically unnecessary building requirements for ambulatory surgical centers, and also the requirement that doctors who provided abortions obtain hospital admitting privileges at a nearby hospital. So in Missouri, we were and many other states that had these laws, we were very excited because we thought that this ruling would also apply to Missouri. Unfortunately, it did not. It only applied to Texas, but it was a good ruling for Texas. But then Texas had a really bad ruling that took effect in 2021, Texas Senate Bill 8, and it was also known as the Bounty Hunter Law. One thing it did was restricted abortion to 6 weeks gestation or less. And what that meant was women could not, most women don't even know that they're pregnant at 6 weeks. So it meant that they couldn't get an abortion in Texas. And I can tell you that Oklahoma, the Planned Parenthood clinics in Oklahoma were just overrun by women from Texas. And that's true still in the Kansas City Planned Parenthood abortion clinic, where so many of their patients come from Texas and other states where abortion is illegal. So copycat bills in other states quickly ensued, and it was taken to the Supreme Court, but they refused to strike it down. Now, the worst thing about the Senate Bill 8 and why it was known as the Bounty Hunter Law is that it incentivized snitching. So it allows, I have to say, it's still in effect, it allows private citizens to sue anyone for aiding or abetting abortion. So if you know that Mary Beck helped somebody to get an abortion by driving her to Kansas City, you could call in on the hotline and report her. And they could be prosecuted by the state of Texas. And if successful, then Mary would have to pay $10,000, at least a minimum of $10,000 under the state law. And you've probably heard of situations where this has been done. I haven't heard of anything where anyone has been awarded this money, but it is still a state on the books in Texas. So now we get to June 24th, 2022. The U.S. Constitution does not confer a right to abortion under the Supreme Court decision known as Dobbs versus Jackson Women's Health Services. It overruled both Roe v. Wade and Planned Parenthood versus Casey, giving the states to regulate any aspect of abortion. And so that's where we are now. We've seen a lot of states doing initiative petitions. So far, they've all been successful. I hope that we'll be successful too in Missouri. I'm going to be working hard on it, and you in Muleskinners, I know, are very politically active, and I hope you'll all be helping us gathering names for the petition and in getting people to pass the initiative petition to restore reproductive rights in Missouri. So now Mary is going to talk to you about what all the horrible things that have happened since the overturning of Roe v. Wade, since the Dobbs decision. And I should say that even since the last time we gave this presentation in December, there have been several new situations that have been in the news. It's just every day it seems like something else is happening. So Mary, I'm happy to turn this over to you now to talk about what's happened since Dobbs.
All right, let me see if I can.
I have to stop screen sharing here.
Okay.
Where do I do that? Oh, it has stopped already.
Yeah.
Okay, there we
I
go.
think so. Okay, so is my, oh, I think I have to go to slideshow. Format. Close the slideshow. I'm sorry. Okay, so obviously I am going to talk about Dobbs at the federal level and then what's happened since then. The holding in Dobbs, gosh, this, there we go. Okay. Wonder if I can get that out of the way. No, I can't. The Constitution.
It looks fine. We don't see anything over
don't?
your screen share.
Okay, good. So the holding in Dobbs basically was that the Constitution does not protect a woman's right to abortion, overruling, as Margie said, Roe v. Wade and Planned Parenthood versus Casey. It gave the authority to regulate abortion to the states, which was a new reality. These are the broad categories of laws passed by the states. They go from an abortion ban from conception on to an abortion ban from even before cardiac activity or until it stops, before certain weeks of gestation, or if it's necessary because the pregnancy is threatening a mother's life. There are medical problems with these limitations. Primarily, miscarriages involving hemorrhages may threaten a mother's life prior to the cessation of cardiac activity or after the gestational week limit. When exactly a mother's life is at risk is a complicated analysis based on a lot of factors, including heart rate, level of consciousness, blood pressure, those would be the big three, then oxygen saturation levels, red blood cell count, hematocrit and hemoglobin, which are iron carrying capacities of blood, pulse pressure, which is the difference between the top and the lower blood pressure numbers, respiratory rate, hemorrhagic flow, pallor, etc. So you can see that when and whether a hemorrhagic miscarriage is threatening a woman's life is not a simple determination. Physicians could disagree over it, and certainly judges and physicians could disagree over it. Chrissy Teigen is a well-known model. She's married to a guy named Legend. He's also famous. They exemplify this difficult balance between law and physiology. So this woman and her husband really wanted the fetus that she was carrying, but she started hemorrhaging, and she didn't want to do a D&C, which is the same thing as a D&E, dilatation and curettage. She didn't want her uterus scraped of this pregnancy because she wanted this baby. But she kept bleeding, and she was hospitalized. And finally, her physician said, this baby's not going to live no matter what you do, even though his heart is still beating. And you're going to die as well as this baby if we don't do a D&C. So she did do a D&C, and for that, she was criticized by her, public, because a D&C is the procedure done for a late term or second, for miscarriages or abortions, D&C. And you can see from this picture, this was not what this woman wanted to do. The relevant medical facts here are that in women under 30 years of age, about 1 in 10 pregnancies miscarries. In women 35 to 39, it's 2 in 10 pregnancies. In women over 45, it's half of all pregnancies. So you can see miscarriage is a common problem for women who are pregnant. About 50% of women who miscarry do not need a D&C. They can safely miscarry on their own, emptying the uterine contents without any assistance. But miscarriages after 10 weeks are more likely to be incomplete, meaning the uterus didn't empty itself without assistance, and a D&C procedure is necessary. A D&C, keep in mind, is one method that can be used when a person chooses to abort a pregnancy. It's the same procedure that is used when a woman is miscarrying and needs assistance emptying her uterus of pregnancy contents. Abortion pills are used in over 50% of abortions. Okay. Medication abortions are a 2-pill regimen of those two drugs, mifepristone and misoprostol. They account for over half of all abortions. The Federal Drug Administration in January, about a year ago, officially removed the in-person requirement for pharmacies to dispense these drugs. Healthcare providers be certified to show they have the knowledge and ability to treat abortion patients is still on the books. 79% of all abortions occurred before 10 weeks, which means that these pills can be responsible for almost 80% of all abortions. 93% of abortions occurred before 13 weeks. That's CDC data. That means that medication abortions would likely be effective in 80% of abortions. Margie already talked about the trap laws. I'm going to talk about them just a bit in terms of what states are doing what. The district court for Texas, that same district court that has issued a number of of rulings that invade the privacy of pregnant women. It recently ordered the Food and Drug Administration to revoke its approval of mifepristone, one of those drugs used in medication abortions. 15 states require that medication abortion be provided by a physician. These are these trap laws that Margie talked about. 5 of those 15 require the patient to have an in-person visit with a physician. 1 state requires that the first of the 2 drug regimen be taken in the presence of a physician, and 1 state bans mailing pills for medication abortion to a patient. That's also on that Guttmacher site that Margie talked about. Interestingly, Aid Access, which is a European service, continues to send pills to women anywhere in the United States, regardless of their state laws. Margie also talked a bit about the ballot initiatives. My understanding right now is that of these states, the only one that did not make a favorable ballot or have a favorable election on abortion ballot initiatives was Louisiana. It approved a no constitutional right to abortion in 2020. Colorado rejected even a 22-week abortion ban. Vermont, California, and Michigan preserved the right to reproductive freedom in their constitutions. Montana rejected a born alive measure. Kansas and Kentucky rejected a no right to abortion in their constitutions. And most recently, Ohio preserved a right to reproductive freedom. Missouri, as Margie said, is in the midst of trying to get its ballot initiative before voters, which is going to require signatures. Who gets an abortion in the United States? It's a woman who is already a mother. She's in her late 20s. She's attended some college. She has low income. She is unmarried. Statistically, she's in her first 6 weeks of pregnancy. She's having her first abortion, and she lives in a blue state. I'm kind of trying to hurry because I know I want to leave some time for questions. Pregnancy versus abortion in terms of risks. Over 1,600 pregnant women died in 2019. 70 women, in addition to those, suffered serious maternal events, morbidity, it says, that meaning they had to go to ICU, CPR, had to have cardiopulmonary resuscitation or transfusions. The mortality risks for pregnant women over 45 is a 10-fold risk. For Black women, it's a 3-fold risk. Mortality from abortion is less than 1%. Mortality associated with pregnancy is almost 9%. So in terms of safety, a woman is much safer having an abortion. And let us not forget that the leading cause of death for pregnant women is domestic homicide. There are not a few women who are afraid to be pregnant because their boyfriend or partner has threatened to kill them. And statistically, that is the leading cause of death for pregnant women. Now, let us look at some of the results in the states that have abortion bans or traps. States with trap laws saw an 11% increase in foster care placements over states without trap laws. 25 million women live in trap states. That means that's a really huge increase in the number of children who are taken into state custody. Black children are disproportionately represented in that increase. The foster care entry statistics show that inadequate housing undergirds a lot of these foster care placements. This was published in Journal of American Medical Association. This means that an already overburdened foster care system is getting more children. Women forced to carry fetuses can't afford them or can't afford their older kids, and these kids are ending up in foster care, which is really a downward spiral for children. Births in states with abortion bans saw a 2.3% increase over states not restricting abortion. That is 32,000 more births than statistically expected since these bans went into place. Interestingly, the increases are greatest in the states with the longest travel times to the nearest abortion provider. In Texas, the birth increase was over 5%. In Mississippi, it was just under 5%. Bilateral tubal ligations are really the most surefire way of helping a woman not get pregnant, but they cost up to $6,000. Under the Affordable Care Act, tubal sterilizations must be fully covered under private health insurance plans, not so vasectomies. But women who want a bilateral tubal ligation funded by Medicaid have to wait 30 days from consent to procedure. One Michigan study and other anecdotal reports show an increase in requests for bilateral tubal ligations post-Dobbs. Women do have an alternative. LARCs are very effective, long-acting reversible contraceptives. They are implantables. Vasectomies, by comparison, cost $1,000 to $1,500. In Missouri, there was a mobile Iowa vasectomy clinic, and it saw a 30 to 50% increase in vasectomies post-Dobbs. In Missouri, in total, vasectomies rose 100%. Planned Parenthood offered a 3-day vasectomy clinic in 3 different Missouri cities. It was open to up to 100 people, and 100 people signed up in all 3 cities. 91 actually got the vasectomies. Now, this is probably not critical, and we have only 5 minutes left. The import of this is that the birth rate has decreased globally and nationally. In the United States, the birth rate is currently 1.7 births per woman, and the replacement level for the population is 2.1 births per woman. So that's a consideration as we talk about abortions. My last slide is not that important. It had to do with those states banning abortion and what the various state statuses were with respect to that. So at that point, I would take questions, and I'm sure Margie would as well.
Who has a question? Carl or Marie.
All right, unmute. At the risk of being sarcastic, is the Texas abortion bounty paid to the snitch?
Yes.
It is.
Well, it hasn't been tested. I mean,
Rather than the state? Interesting.
it's an incentive to snitch.
That's
It
why
wouldn't
it's
be
called a
much an
bounty.
incentive. It wouldn't be an incentive if the money was going to the state.
Well, it would be satisfaction. I'm not sure. Some of these
Yeah.
people are a little twisted, but nonetheless.
David?
You know, for some reason my raise hand icon, I can't find, or it's not working. Just a question. These are great slides, wonderful history. I was not aware of most of this. Can we get copies of these 2 sets of PowerPoint slides?
I'm happy to share mine. I'll send them to, I think I already sent it to Alice, but I'll send it again because I added 1 slide.
Okay, thank you.
There are
Yeah.
a couple questions in the chat.
Oh. Oh, thank you, Carl, for pointing out that those statistics were not percentages.
Okay,
Yes,
I'll jump
Yeah,
in. And
They were per 100,000.
I was moving too fast. Thank you.
if no one else has got a question, I really have one. So when Dobbs came through and they overruled Casey, what happened to the jurisprudence that was in Casey declaring when it's appropriate to overturn a precedent? Yeah, I know that, there's a lawyer here, right? What happened to that jurisprudence? Did that go away too?
Well, Planned Parenthood versus Casey was overruled. So I thought one of the key provisions in there was that the husband, didn't have veto power. So that's gone. That's up to the states now again.
Well, what I'm getting to is what was the substantial change in fact that the court
Can you
could
turn that-
rely upon, or what was the substantial change in not understanding of relations, like like in Brown versus Board of Education. There were like three things in Casey that clearly laid out, hey, if one of these three things has happened, then we've got to really consider our precedent. And it wasn't clear to me what had changed since Casey on those. I'm asking the lawyer to help me out here. I'm looking for the intellectual dishonesty of opposition.
I would have to reread that section of Dobbs that was devoted to Casey. Margie, do you remember the particulars?
Not for what Dave is asking.
Okay.
I mean, it was overruled, so the provisions of Casey were, you know,
Every one of them. Okay.
A really dangerous part of Dobbs was Thomas's concurrence, in which he said he thought that substantive due process needed to be reviewed. And he specifically mentioned Griswold, Eisenstadt, Obergefell, Lawrence v. Texas.
Okay, and so Loving is not a substantive due process case, that's an equal protection case, and that's why he thinks he's safe? He's married to a white woman.
I don't hear well, so I'm not sure that I heard that. Substantive due.
Yeah, so Loving is not a substantive due process case, it's an equal protection case, and that's why Clarence thinks he's safe being married to a white woman. If I can, this is
He
how
left
I
that
talk
one
about
out.
things. Yeah, well, okay.
Yeah.
One thing I would-
point
one
out
thing-
Sorry, there are a couple of questions in the chat that haven't been addressed yet.
Yeah, Dave Taylor asked if there's been any indication yet of decreased availability of medical services, in as much as some medical professionals don't want to practice in a state that bans abortion.
Well, I do know that the recruitment of residents to OBGYN residencies has been affected because a lot of people don't want to go to states where they're not going to be able to learn how to perform an abortion or be able to do abortions. And, another thing is that a lot of, I have heard anecdotally of doctors you hear in the news of doctors leaving states because of the laws. And I think very significantly, we're seeing things like this woman, Kate Collins in Texas, who had to leave the state because Texas would not allow, and the Supreme Court, turned her down also. She had a fetal viability issue, a big genetic problem that would lead to the death of the infant as well as to her potentially. And she had to leave the state. They wouldn't allow her, even though the law said to save the life of the mother, they weren't upholding that. I read just recently about a woman in Tennessee who had to leave Tennessee to get, she also had a wanted pregnancy, had to leave the state because of the fetal viability issue, was not allowed to get an abortion in Tennessee. And she's now running for the state legislature in Tennessee. So, in some ways, Dobbs has, it's brought back our public discussion about abortion. I think most of us can really sympathize with women who have wanted pregnancies, but medical problems with them and they're not allowed to terminate the pregnancies in their own states. We're hearing about just the tip of the iceberg, that probably happens more often than gets into the news.
Yeah, I know that a woman in St. Louis died because she couldn't get to Illinois fast enough to have her miscarriage surgically treated. So yeah, we are just hearing the tip of the iceberg. And to answer Dave Taylor's question, yes, I think there are many healthcare providers who are reluctant even to do life-saving procedures on miscarrying women, because while the physician might say, well, I'll take the risk, he's not going to take the risk for the surgical techs in the room with him or the anesthesiologist or anyone else. So he's going to err on the side of caution because he doesn't want to expose his colleagues to lawsuit. So I think that's probably why the woman in St. Louis lost her life.
Dave Bluefield?
Oh, I wanted to ask about the initiative petition. It seems to me like you have a very hard, difficult hill to climb. You need 170,000 signatures by the 17th of May, and you need to collect apparently another $4 million to.
Do not underestimate the wrath of women. We'll get the signatures.
That relates to another question. Are there multiple petitions out there, and can somebody sign more than one petition?
I think there's only going to be, well, there is a petition from a woman in St. Louis, but this current one that's coming out is, they did get the coalition to agree on the language, and I think it's all just one petition.
Margie,
hope-
can you describe that a little bit? Because there's something about the legislature in there too. Are you familiar with it?
I am not, and I know that Wynn Caldwell had a question she wanted to ask, so let's let her ask that.
Yeah, Wynn. You're mute, Wynn. Wynn, we can't hear you.
So is the petition is not in a form that we can sign yet?
It's at the printer, and we're expecting it'll be here the first week of February.
Good.
And
will there be
and-
copies available at the library, do you think? How could people in general access?
I don't know yet. I talked to the CEO of Planned Parenthood Great Plains yesterday, and it's being coordinated centrally, and we'll find out like if there's going to be a central location where they can be picked up and dropped off. So I just don't know yet.
But if I can put in a plug, the League of Women Voters is going to be recruiting our members to agree to pass around the petition to their friends and acquaintances and events that they go to and so on. So and Margie is our liaison with the state league on that. So we will be putting out more information to league members anyway, and I'd be happy to share it with the Muleskinners as well as to how all that's going to work. But yeah, we're going to need to get a lot of petitions out there. The good news is, and this is ironic, since Boone County was gerrymandered into 2 different congressional districts, we can impact signature collection in both District 3 and District 4. So we're going to work really hard to do that.
David Mallory.
Another bit of good news is that the firm that was hired to coordinate all this is the same firm that did it in Ohio, and we know they did a great job there. So I was happy to hear that.
Final comment from David Mallory.
But yeah, my question is related to the petition. I see a lot of petitions to be signed just outside the library. Is there any thought been given to having petitions somewhere where people can come to? They don't happen to go to the library all the time.
I think there will be a place, but we don't know where that's going to be.
Let us know, and we can get that publicize that. So that's something I've never heard of for other petitions. I'm like, there are people who want to sign this, just don't know where to go and who to talk to. So
Come to the chili supper.
Yeah, and often that was like art in the park, and some of the chili suppers another good example. There should be lots of opportunities, but we need to identify them and put that stuff at various events.
Will there
And
be
I-
people outside the DMV offices? That's where I usually see them.
Oh, well, that's a good thought.
That's a good
We'll add
thought,
that to
yeah.
the list.
Farmers market, yeah.
Well, thank you, Mary and Margie. Very informative
I-
presentation.
I can say one other thing that, you know, you heard initially that we had to raise $1 million in order to get some national group to give us, or give whoever, the coalition, an additional $4 million. And that was going to be to sign a contract with a firm that does petitioning. And so we will have paid petitioners everywhere as well as volunteer petitioners.
Well, thank you very much. And
If I can add, that $1 million has been raised.
Yeah,
Just what-
121.
It was raised and the 4 million match was given. And yeah. So we need to gather signatures for the petitions. That's going to be over May 5th. And then we're going to need to raise a lot of money. I heard the initial goal was $25 million, but the cost in states like Michigan and Ohio was 40 to 50 million, and they anticipate it'll go way up from 25 million. So,
Oh, my.
you know, I hate that we have to put so much money into this, but, you know, that's what
Like
what
having
it
to
takes.
replace, it's like having to replace broken windows, you know, you're just trying to get back to where you were before some asshole came along and broke shit.
I'd just like to thank both Margie and Mary for their work at the many past years and currently. I
Thank you.
think it's so important and so we appreciate all the effort that you made to put into this and make it available.
Thank you. I'm sorry that we're still in this fight
Yes.
this year.
okay,
Bye,
let's
everybody.
begin the regular portion of our meeting. And are there